This is the fourth and final video on our series on how rights are protected in Australia. So far, we've seen that rights are protected in Australia by firstly, statute, secondly, the common law, thirdly, the Australian Constitution, and in this video, we're going to look at the final way in which rights are protected in Australia, which is through international declarations and treaties. There are two things that you need to do while you're watching this video. The first thing is to take the very best Cornell notes that you can. The second thing is to use the pause function so that you can pause this video if you need to take some notes. And also, you must use the rewind function so that you can rewind this video if you have missed information or need to go back over any information. Once you have finished watching this video, please read sections 15.5 and 15.6 of the textbook and supplement your notes with any information from that reading that you find useful. Here is our learning intention for this video. By the end of this video, you should be able to evaluate the ways in which rights are protected in Australia by, in this case, international declarations and treaties. Make sure that you write this learning intention down in your Cornell notes. By way of recap, this slide sets out the four ways in which rights are protected in Australia. Firstly, through statute law. There are statutes that have been passed by the Commonwealth and Victorian parliaments that protect many of the rights that we enjoy today. For example, there is legislation that prohibits people being discriminated against on the basis of their gender, sexual orientation, religious beliefs, or race. Put another way, these statutes give us rights not to be discriminated against on the basis of our gender, sexual orientation, religious beliefs, or race. We have also looked at the Victorian Charter of Human Rights and Responsibilities, which sets out some of the rights that people in Victoria enjoy. The second way in which rights are protected in Australia is under the common law. The common law is law made by judges when they are deciding cases. So far, we have looked at the right to silence and the right to a fair trial. These are rights that judges have developed through making decisions in cases that they have heard. The third way in which rights are protected in Australia is under the Australian Constitution. The Australian Constitution protects rights by restricting the law-making powers of Parliament. For example, the Australian Constitution prohibits the Commonwealth Parliament from making laws that restrict the right of religious freedom. The final way through which rights are protected in Australia is by international treaties and declarations. This is what we're looking at in this video. The Commonwealth Government has signed a number of declarations and treaties, such as, for example, the Universal Declaration of Human Rights. These kinds of instruments, that is, these treaties and declarations, impose obligations on Australia to protect rights. However, we, as Australian citizens, can't enforce those rights unless the Commonwealth Parliament has first passed legislation that gives those rights to us. You'll notice that I have referred to two different kinds of instruments: international declarations on the one hand and international treaties on the other hand. The difference between them is the extent to which they impose binding obligations on the countries that sign them. An international treaty is a binding agreement between countries. That means that where countries sign an international treaty, they must comply with the obligations that are imposed on them under that international treaty. An example of an international treaty is the United Nations Convention on the Rights of the Child. Other names for treaties are conventions, protocols, and covenants. A treaty may be just between two countries, in which case it is called a bilateral treaty, or else it may be between 3 or more countries, in which case it is called a multilateral treaty. Multilateral treaties are typically developed by an international organisation such as the United Nations, and then countries are invited to sign up to that treaty. An international declaration is a non-binding agreement between countries. In other words, an international declaration does not set out obligations that the countries that sign the declaration are required to comply with. Instead, an international declaration just sets out the hopes or aspirations and intentions of the countries that have signed that declaration. An example of an international declaration is the Universal Declaration of Human Rights. Declarations are also known as instruments, statements of principle, MOUs, that is Memorandums of Understanding, or recommendations. This slide sets out how the rights created under international declarations and international treaties can become part of Australian law and therefore part of the rights that the Australian people enjoy and can enforce. Let's look at declarations first of all. For Australia to become a party to a declaration, the Commonwealth Government must first sign or enter into that declaration. Now remember that an international declaration is not binding, so even when Australia has signed an international declaration, it's not bound to implement or give effect to the rights contained in that declaration. Nonetheless, the Commonwealth Parliament might then choose to pass legislation that does implement or give effect to that declaration. And it's only if the Commonwealth Parliament passes legislation that implements or gives effect to that declaration that the rights created under the declaration will become rights under Australian law that can be enforced by the Australian people. In the absence of this legislation, the Australian people would not have the rights which are created by the declaration. It's only because the legislation makes the rights created under the declaration part of Australian law that these rights can be enjoyed and enforced by the Australian people. Now let's look at the situation regarding international treaties. Once again, for Australia to become a party to an international treaty, the Commonwealth Government must first sign or enter into that treaty. But even though Australia has signed the treaty, at this stage the treaty does not bind Australia. Instead, for the treaty to become binding on Australia, the Commonwealth Government must take a further step, which is to ratify or approve that treaty. It's only once a treaty has been ratified that the treaty is binding on Australia under international law. However, at this stage, the treaty and the rights created by the treaty are still not part of Australian law. Once a treaty has been ratified, then the Commonwealth Government is bound to implement the provisions of that treaty. And so what the Commonwealth Government will do is that it will introduce legislation into the Commonwealth Parliament that implements or gives effect to the treaty. Assuming that legislation is passed by the Commonwealth Parliament, only then will the rights created by that international treaty become rights under Australian law that can be enforced by the Australian people. Again, in the absence of this legislation, the Australian people would not have the rights that are created by the treaty. It's only because this legislation makes the rights created under the treaty part of Australian law that those rights can be enjoyed and enforced by the Australian people. The Commonwealth Government has signed a number of international declarations and treaties that require Australia to protect human rights, and we'll be looking at a few examples of these in a moment. But the fact that the Commonwealth Government has signed a declaration or treaty doesn't necessarily mean that those rights will be given to the Australian people, or that even if they are given to the Australian people, that they won't subsequently be taken away. Remember, It's only if the Commonwealth Parliament passes legislation that gives effect to the rights set out in an international declaration or treaty that the Australian people will be able to enjoy and enforce those rights as part of Australian law. In addition, even if the Commonwealth Government does sign a declaration or treaty, it can subsequently withdraw Australia from that declaration or treaty. In such a case, it's highly likely that the Commonwealth Government will then introduce into Parliament legislation to take away the rights that were created by that declaration or treaty. Even if the Commonwealth Government doesn't sign an international declaration or treaty, either the Commonwealth Parliament or a state parliament might pass legislation that is influenced by the rights set out in that international declaration or treaty. For example, the Victorian Charter of Human Rights and Responsibilities, which is Victorian legislation, contains a number of rights that are set out in the International Covenant on Civil and Political Rights. We've already looked at those. But again, even where the Commonwealth and state parliaments do pass legislation that contains rights that are set out in or influenced by international declarations or treaties, Parliament, being supreme, can amend that legislation to change or take away those rights. This table sets out a number of rights that are created by some international declarations that Australia has signed. You don't need to remember all of these rights, but what I would suggest is that you remember a couple of rights as examples of the kind of rights that are protected by international declarations. We've already referred to the Universal Declaration of Human Rights, and you can see that this declaration creates a number of very fundamental human rights. There's the right to life, liberty, and security of the person, the right not to be held in slavery or subjected to torture or cruel, inhuman or degrading treatment or punishment, the right to be treated equally before the law and to have a fair and public hearing by an independent and impartial tribunal. You might recall that there's a very similar right contained in the Victorian Charter of Human Rights and Responsibilities. There's also the right to asylum from persecution in other countries. That means there is the right that refugees who are fleeing from countries where they run a serious risk of being killed or seriously injured, they have a right to seek safe haven or asylum in another country. There is the right to marry, providing that that marriage is between consenting parties. That is, both spouses must consent to the marriage. There's the right to take part in political processes, whether that's to participate in Parliament, to participate in demonstrations, or some other form of political expression. And finally, there's the right to freedom of opinion and expression. Under the Declaration on the Rights of Indigenous people are given the right to be treated equally or the same as other people who live in that country. And they're also given the right to nationality, that is, the right to recognise themselves as belonging to a distinct group within a country. And finally, we have the Universal Declaration on Cultural Diversity, which contains the right for people to be treated equally, irrespective of their cultural identity, and the right of people to be able to express themselves in their language of choice. That is, not to have a particular language forced upon them as the language which they must always use. In this table, I've set out a number of examples of rights that are protected by international treaties that Australia has signed. And you'll also see that I've included a column here which sets out the statute or legislation that has been passed that gives effect to that international treaty as part of Australian law. So, if we're looking for our right to freedom from racial discrimination, that is a right which has been set out in the International Convention on the Elimination of All Forms of Racial Discrimination. And Australia is a party to that international treaty, and as part of its obligations under that treaty, the Commonwealth Parliament then passed the Racial Discrimination Act 1975, which enshrines in Australian law the right of people to be free from racial discrimination. Similarly, you can see that there are rights to freedom from discrimination because of disability, because of gender, and because of age. These are all rights which are recognised under international treaties. The Convention on the Rights of Persons with Disabilities, the Convention on the Elimination of All Forms of Discrimination Against Women, and the International Covenant on Economic, Social and Cultural Rights. Because Australia has signed up to these treaties, it is obliged to implement those rights as part of Australian law, and it's done that through the Commonwealth Parliament passing the Disability Discrimination Act, the Sex Discrimination Act, and the Age Discrimination Act. Another right is the right of children to have their best interests as the paramount consideration in a court order regarding custody. That is, when parents divorce and there is a dispute over the custody arrangements for the children, then in making an order about those custody arrangements, the court must have regard to the child's best interests. That is the primary consideration that the court must have regard to. That right arises from the Convention on the Rights of the Child, and that right has been enshrined by the Commonwealth Parliament in the Family Law Act 1975. And the final example I've given you here is the right of refugees to have their application for asylum processed in accordance with international obligations. That is a right which is created by the Convention relating to the status of refugees, and we find that right reflected in the Commonwealth Migration Act of 1958. Now again, you don't need to remember all of these rights, international treaties and Australian statutes. I just suggest that you remember one or two so that you can provide an example of a right, an example of an international treaty under which that right is created, and an example of an Australian statute which then creates that right as part of Australian law. That now brings us to the question of what happens if Australia, being a party to an international treaty, breaches its obligations under that treaty. You'll recall that a treaty is only binding on Australia when the Commonwealth Government has ratified it. Well, there is no global system for enforcing countries' obligations under international treaties. That is, there's no court or other body that has the responsibility or power to require a country to comply with its obligations under treaties that that country has signed. You might think that that means that treaties are hardly worth the paper they're written on. Well, in fact, there are some mechanisms which are available and which operate by pressuring governments to comply with their obligations under treaties, even if they can't compel the governments to comply. The first mechanism is the International Court of Justice. This is a court which has been set up to resolve disputes between countries where those disputes arise under treaties that the countries have signed. Now, a limitation of this mechanism is that the court only has jurisdiction to resolve a dispute where the countries that are party to that dispute agree that the court should resolve the dispute. The second mechanism is that some treaties establish committees to hear disputes arising under the treaty or to monitor compliance by countries with the treaty. So, for example, we have the United Nations Human Rights Committee, which has been set up to hear disputes under the International Covenant on Civil and Political Rights. A limitation of this committee is that it can't compel countries to comply with the International Covenant on Civil and Political Rights. However, what it can do is investigate suspected breaches of that international covenant and report on those breaches. By publicising that report, it seeks to pressure or shame the country that has breached that international covenant into complying with its obligations under that treaty. We've seen a recent example of that in Australia, and this is referred to on page 504 of the textbook. That is a case where the United Nations Human Rights Committee investigated breaches by Australia of the International Covenant on Civil and Political Rights in its detention arrangements for young people, and you can read that case study. In that case, the committee released a report which was critical of Australia, and that is one of the factors that has led to reforms in the detention and keeping of youths in custody in Australia. The third mechanism is that there are a number of international organisations that seek to pressure governments to comply with their treaty obligations. Examples of these international organisations include the United Nations Office of the High Commissioner for Human Rights, and also non-government organisations such as Amnesty International and Human Rights Watch. These bodies monitor compliance by countries with their obligations under treaties, particularly human rights obligations, and they will publicise reports where they believe that countries are not living up to those obligations. The purpose of that publicity is, of course, to try to pressure or shame countries into complying with their treaty obligations. In this regard, Australia has been criticised by both the United Nations Office of the Commissioner for Human Rights and by Amnesty International for its offshore detention arrangements for asylum seekers, and also for the fact that there's a disproportionately high number of Indigenous adults and youths in Australian jails. To some degree, that has had some effect. So, for example, in the case of the detention of Indigenous people, the Australian government and also state governments have been looking at how to reduce the number of Indigenous people who are kept in detention. In accordance with the learning intention, you should now be able to evaluate the ways in which rights are protected in Australia through international declarations and treaties. In previous videos, I have provided you with a table that sets out the strengths and weaknesses of statute, common law, and the Australian Constitution in protecting rights in Australia. However, this time I would like you to draw up your own table of the strengths and weaknesses of international declarations and treaties in protecting rights in Australia. You will use this table to assist you to evaluate and to write an evaluation of the effectiveness of international declarations and treaties in protecting rights in Australia. Thank you very much for your attention.